Hi friends, good morning. This is Dr. Harinath Reddy, Faculty for Indian Polity and Constitution. Today in this particular video, we will try to discuss about an important judgment given by the Supreme Court recently on Article 39B. Article 39B of the Indian Constitution deals with material resources of the community to be distributed for the common good. And Article 39B is part of directive principles of state policy. So the recent judgment is about the relationship between fundamental rights and the directive principles of state policy. So in a recent case known as Property Owners Association versus State of Maharashtra, Property Owners Association versus State of Maharashtra 2024, a 9-judge bench of the Indian Supreme Court by 7:2 majority said that all private property doesn't come under the definition of material resources of the community. So the consequence of this judgment is, if all the private property doesn't come under the definition of material resources of the community, all kinds of private property cannot be acquired by the state for a distribution to serve the common good. Instead, in this case, the Supreme Court said, for a private property to be defined as a material resources of the community, it depends on the nature of the resource. For example, if the resource is scarce, if it is expensive, and if this resource is necessary for serving the larger public interest, then such kind of private property can be acquired under the definition of material resource of the community. So this case came in the background of a law made by the Maharashtra state legislature. We all know that Mumbai city is located in the coastal areas. In Mumbai city, before 1940, several buildings which were constructed in Mumbai city before 1940, now they were in dilapidated condition, and these buildings are not safe for habitation. So state legislature in 1976 has passed a law, Housing and Area Development Act 1976, which was amended in 1986. So this law provided for acquiring these dilapidated condition buildings from the property owners at a throwaway price and then distributing them for the tenants under certain conditions. So the property owners of these buildings, they have challenged the acquisition and the constitutionality of the Maharashtra law before the Supreme Court. And then there are several other earlier cases decided by the Indian Supreme Court as part of Article 39B. So some of the judgments include State of Karnataka versus Ranganath Reddy 1977. So this is a judgment by a 7-judge bench by 4:3 majority. So in 1970s, Karnataka state legislature has passed a law for acquiring the private transport by the government. So this law was challenged before the Supreme Court by Ranganath Reddy, who is a private transport operator. So Ranganath Reddy challenged the constitutionality of this law on the argument that it violated Article 14 and Article 19(1)(g) of the Indian Constitution. But the Supreme Court has declared that law as constitutionally valid because in the Constitution of India there is one article, Article 31C. Article 31C was inserted in 1971 by the 25th Amendment. Article 31C says, laws made by Indian Parliament, laws made by the state legislatures for implementing 39B and C can take away the fundamental rights guaranteed by Article 14 and 19. See, Article 39B speaks about distributing the material resources for common good. Article 39C speaks about preventing concentration of wealth. So the mandate in Article 39B and C is to lay a foundation for the establishment of an egalitarian society. So any law made by Parliament and state legislature in the direction of building an equal society can take away the fundamental rights guaranteed by Article 14 and 19. So in State of Karnataka versus Ranganath Reddy, a 7-judge bench by 4:3 majority said that all private owned resources, they don't come under the definition of material resources of the community. But in this case, Justice Krishna Iyer gave a minority opinion and he differed with the majority and he said that all private property comes under the definition of the material resources of the community. And this is the case which was decided in 1977. Subsequently, in 1983, there was one more case decided by the Supreme Court. This case is called Sanjeev Coke Manufacturing Company versus Bharat Coking Coal Limited 1983. This was a 5-judge bench of the Indian Supreme Court. In this case, the Supreme Court said all private owned resources, they come under the definition of the material resources of the community. So this view is in tune with the minority opinion expressed by Justice Krishna Iyer. Subsequently, in 1997, in Mafatlal Industries Limited versus Union of India, a 9-judge bench of the Indian Supreme Court again said that all private owned resources, they come under the definition of material resources of the community under Article 39B. The definition of material resources cannot be confined only to natural resources or man-made resources or only government-owned resources. All kinds of private-owned resources, they also come under the definition of the material resource, which means the state will have an unlimited power to acquire such resources for distribution to serve the common good. So in the light of these judgments, recently in November 5th of this month, the Supreme Court in Property Owners Association versus State of Maharashtra 2024, a 9-judge bench by 7:2 majority has decided that all private property doesn't come under the definition of the material resources of the community. There shall be a criteria to consider the private property as a material resource. As I said earlier, if the resource is scarce, if it is expensive, and if this resource is vital for serving the larger public interest, then such a private property can be called as a material resource under Article 39B. And Justice B. Nagaratna agreed with the majority opinion when it comes to that all private property doesn't come under the definition of the material resources of the community. Justice Dhulia gave a dissenting judgment. He did not agree with the majority. He said, like Justice Krishna Iyer, all private property, it comes under the definition of material resources of the community. So this is a significant judgment trying to balance fundamental rights and the directive principles of state policy. As a consequence of this judgment, today in India, the power of the state to acquire private property under Article 39B is no more an unlimited power. So it is a limited power. Only in certain compelling situations, private property having larger public interest can be acquired as material resource for distribution to serve the common good. So that's it about in this video. Thank you and all the best for the students.